Welcome to EMBARGOED, intelligent talk about sanctions, export controls, and all things international trade. I'm one of your hosts, Tim O'Toole, and with me is my friend, colleague, and co-host for today, Doug Jacobson. Doug, welcome.
Thanks very much, Tim. Good to be here.
Good to have you.
Good to be back.
That's true, and you did promise to come back, and now you're keeping your promise in the new year. And it's good to have you. So today we are going to talk all about last year. We're going to do that in the export controls context. And so I think what we'll do is we'll talk about some of the big developments in both BIS and ITAR, some of their big announcements, some of their enforcement cases, and then we'll kind of move to some country-specific developments. So a little bit about the special export controls restrictions with respect to Russia, and a little bit about the topic that we talked about last year, the supercomputer rules. So we'll go through a little bit of that again because they were obviously so important, and now a couple months in, we might have some more observations to make about those, about how they're actually playing out.
And still dealing with it every day.
Exactly. Me too. And I think in some ways it's gotten a little bit more it's a little bit more concrete than when we talked the last time, in terms of, I think obviously this rule was designed to go to deal with supercomputers and super chips, but at least I've run into issues, and I'm sure you have too, where there might be some products that might not fall within those categories, might be a little bit lower level, that have been swept in or potentially by the rule. So we'll get to that at the end. So let's start with some of the big events in 2022, and I wanted to first start with Matt Axelrod's June 30th, 2022 memo. It was an administrative enforcement memo from BIS. It actually got a lot of publicity when it came out. And the topic that got a lot of publicity, I would say the most publicity, the main thing that I'd heard about it, to be honest, until I ran into it in one of my cases, was this provision that talks about, and the way that it's headlined in the memo is elimination of no admit, no deny settlements. And the way that has been reported, and I think some of the publications that I have seen that have kind of described it, have talked about admissions of liability, and obviously that is potentially very dangerous if you are a corporation and you face potential shareholder lawsuits where you would actually you'd be admitting liability, and so if a shareholder sued, they'd actually start with this admission of liability, and it would make it easier to sue. When you dig through the fine print, there's no requirement that there be an admission of liability. It does say that the company has to, or the person has to, quote, admit their conduct. And that is a little bit different. So what I'll throw out to you is, Doug, kind of how do you feel about this part of the new enforcement memo? And have you had it come up, and, do you see it as a big change, or kind of more of a rhetorical change from BIS?
So just to the background, the level set, I think, for people who may not be dealing with this every day, is that there is a new sheriff in town. So you have a new administration, which has now been on the ground for 2 years, but really only in last year, for the most part, was able to kind of either get confirmed and then now starting to put their own stamp on the agency. And this was part of that. There was also a similar policy change as it relates to enforcement for anti-boycott issues, which we can also talk about. And then the other point is that BIS has been relatively slow when it comes to settlement negotiations and final settlements of pending cases. So as we all know, that from the point of an investigation, from the point of a charging letter or proposed charging letter, getting to a charging letter, then the company with counsel and BIS negotiating the potential settlement, that process takes a long time. and it can take several years for those of us who deal with this on a regular basis. And I think I'm always careful to advise my clients that this is going to be a long process, which in many cases the clients are not concerned about as much, as long as the end result is hopefully a lower penalty as a result of those drawn out negotiations. So in terms of whether we're going to see, I haven't dealt with this too often because there haven't been as, this is only not even 6 months ago, and it's affecting, it's also a little bit unclear as to which cases it's going to apply to. I think that's a bit of a question.
Although I will say, I mean, I've had some experience with this now at this point, and there is some question from the memo in my mind as to whether it would be retroactive. Is this for cases where they haven't started enforcement? Is this for cases where the conduct comes after the date of the memo? But at least in my experience, if they haven't settled it, then it's covered by this policy.
Yeah, and I would agree there as well. Now, when it comes to your specific point about the admission of conduct, I think it's much more of a semantic change than a real practical change, because the prior settlement agreements, even though you could sign it and you are not admitting liability per se, the facts were stated there, and it was crystal clear as to in great detail. Not only in the final settlement, but also in the order.
Yep.
And they also attach as in every agreement, they also put in a copy of the proposed charging letter,
yep,
which includes each of the counts, which includes a very detailed paragraph of the activity, of the alleged activity. Right. So I think that when it comes to advising a client as to whether that's going to make a material difference in terms of their ability to agree to admit to that liability, or this is something we should talk about voluntary disclosures in a second, because that kind of goes in hand with this. But I don't think it's really a material change from the company's perspective. Or an individual, if that's the case. I do agree with your point that you mentioned that this could change the equation with respect to shareholder lawsuits where a company is admitting to something, but you're right, they are admitting to conduct. But if you are signing a settlement agreement that sets forth the facts, you are admitting those facts and agreeing to those facts anyway.
Right. I mean, that's what I don't see as much of a change, is the sense that, like, okay, so I get it. If you're bringing a lawsuit and you're plaintiff's counsel, now you'll be able to say, well, you admitted to those facts, and those facts were admitted by the company. But before, you had what I think any lawyer who's an advocate would say was at least a tacit admission, because they recited all these facts and you signed the statement and you paid a bunch of money and you didn't sit there and say, no, none of these facts are true. We object completely to all of the facts. And you weren't allowed to say that because you wouldn't have been able to do the settlement. And so from a plaintiff's lawyer's perspective, I would think that would be so close to the same thing as to really not be much of a difference.
Yeah, and these cases are all made public, and so they're. And I think when it comes, I'm not a shareholder liability expert by any means in terms of, but I do think that when it comes to a shareholder action, I mean, most of these cases in terms of the monetary penalty amount, I mean, unless it's going to be a very large case like a Weatherford or Schlumberger or the like, when you have a publicly traded company involved, I don't think it's, number one, these cases typically are not material,
right?
To a company's, and number two, companies If they are publicly traded, they are going to they are going to, as a general rule, particularly on a very large potential penalty, they are going to set aside funds in terms of an escrow to be able to pay for that. So it's not going to typically decrease shareholder value. It's not going to decrease share price. And therefore, I'm not sure really whether there would be much room for a shareholder plaintiff's attorney to really use this as a hook versus what it would be today.
Yeah, I think so too. I think it strikes me as, it certainly makes rhetorical sense, but as a practical matter, these seem like you were admitting to the conduct already. They're just expressly making you do it, and I'm not a shareholders, lawsuit expert either, so I can't say for sure that it is not going to make a difference. But my sense as someone who kind of has done some litigation both on the civil side and on the criminal side is that I can't see the fact that, you signed a settlement agreement, put your name to it with all of these facts in it, but you didn't say, I admit these facts are true, but you paid your penalty and you didn't object, is very different than a situation where you do exactly the same thing, except for you say, I admit these facts are true. I'm not sure it's going to save much from the lawsuit that eventually results, but could be wrong.
And one final point on that is that the memo does say that you only have to admit liability to get the mitigation credit.
Right.
To a reduced penalty is what it says. So you could, if a company was reluctant to admit the conduct, they could roll the dice and they can say, well, we're not going to admit, and we will use the prior language that BIS has used for years and years, and that at the expense of possibly a higher penalty. So that would be, I would be surprised if a company decided to do that, but we as counsel can give the company the option.
Yeah, and I'd be curious to see what BIS did to a company that came in and said that, because the fact is they say, when we enter a settlement, we're giving you a reduced penalty. So, they're not saying what that is. And so they're saying to earn that reduced penalty. So I guess if you would get no credit and they would put the settlement or the penalty up to the maximum, but you could not admit liability, I guess, but I'm not sure I could even see that scenario arising. I did want to quickly go to the three other things that are in this memo, because it was basically we're going to get tougher on export enforcement memo, and they talked about 4 policy changes. The first one is significantly higher penalties, and as we'll talk about in a few minutes, at least there's been no time to see that happening yet. But one thing that in that section was it was interesting to me, and that is that they say they're going to start calling cases egregious more often. And that one I actually think could make some difference, because I'm not thinking of any off the top of my head, but I know when I read through both BIS and OFAC settlements that I am sometimes puzzled between in trying to figure out the difference between an egregious case and a non-egregious case, because the egregious cases seem few and far between, and the non-egregious cases are pretty common, even when the conduct, when you look at it from the outside, looks pretty similar to some of the egregious cases. And so I'll be curious to see how that plays out.
Well, I'm concerned about that. I'm concerned about the impact of higher penalties, how that will play out. As you say, time will tell. The other thing that I am very concerned about is also that the egregious, OFAC is inconsistent when it comes to egregious.
100%.
My view is kind of, I look at the term egregious, is that I can define it, I know it when I see it. And I can have a pretty good reaction based upon the facts as to whether it's egregious or not. But we were involved in a relatively recent OFAC case where OFAC felt the conduct to be egregious, and we strenuously disagreed and pushed back. We, in fact, did a whole analysis. We got some law clerks to do a summary. We pulled all of the egregious cases that OFAC has, issued, which, there's not a lot, but, and we compared those facts of those cases to our case, and we tried to get OFAC to change their mind on that, and it was not successful. And it was disappointing, actually.
Well, I mean, that brings up 2 points. I mean, and just to level set here a little bit, for folks who don't do this work a lot, when you're dealing with the enforcement guidelines for both OFAC and for BIS, they have a few factors that they really look at in coming up with a presumptive penalty. And one is whether there was a voluntary disclosure, and the other factor generally is whether or not the case is egregious. So egregious or non-egregious is a critical factor, and both at OFAC and BIS, I think it's fair to say that very, very few cases go into the egregious bucket. But I've seen some cases go into the egregious bucket that are, like Doug says, they don't look egregious to me. And then I've seen other cases that don't go into the egregious bucket that have like management culpability and potentially even willfulness and large number of transactions and last over a long period of time, and they find non-egregious. And so it really is hard for me to put my finger on when a case is egregious and when it's not egregious. I usually feel like I know it when I see it too, but there are some cases that I see it and OFAC doesn't, and other cases where I don't see it and they do. So I feel like maybe I don't know when I see it, even though I think I do.
Yeah, I would just say it is ultimately subjective, and I think that's problematic for those of us, who you're trying to get consistency and fairness in terms of all across all the cases. And, in the mitigation guidelines and their enforcement guidelines are trying to achieve that with the factors and using what David Mills had done at BIS, trying to use the OFAC model and trying to come up with consistency and predictability, but it doesn't always work that way.
Yep. So let's move on to the two other ones, because I think we can go through those quickly, and they're kind of similar. So essentially, they're going to start having, and OFAC does this as well, they're going to have non-monetary resolutions, public resolutions for what they view as less serious violations. So essentially, OFAC calls these finding of violations.
Right.
I'm not sure if BIS, I don't think that Secretary Axelrod used that particular term, but I assume that's basically what this will be, is a public resolution without a penalty. What do you think of that?
I don't have a problem with that. I mean, OFAC, as long as it's used sparingly. I mean, again, OFAC uses finding of violations relatively rare when they're trying to make a point. Yep. But when it comes to our clients, if they can have a finding of a violation with zero penalty compared to a penalty, then they're going to take that option every day.
Yeah, I tend to agree. I mean, I do think that the one thing about it that is a little bit weird is that you're usually talking about conduct that would result in a warning letter, but it doesn't, because they're trying to make a point. And from the client's perspective, if there's no penalty, the client usually isn't going to care that much, but it does turn a non-public resolution that nobody ever finds out about unless they go through a pretty laborious FOIA process into a public resolution where the company essentially is found to have violated the either the sanctions or the export controls laws, and it's for conduct that was the same as everybody else did that got a warning letter, but it just happened to be in an area where the enforcement agency thought that it could make a point. So I do think that seems kind of random, although I've run into it in my practice, and I'm sure you have in yours, and it's just kind of being in the wrong place at the wrong time. But it does make a point, and it sure is a lot better than getting a penalty.
Well, the one thing that I think is different amongst with this policy and OFAC, and we'll see how it plays out, is it does give BIS the option of other remedies, such as enhancements to compliance program, maybe an audit, suspended denial order, And so it gives them more flexibility. Now, OFAC does not mandate those other requirements. In a finding a violation, they don't say, well, as condition, you're going to have to, hire a third-party audit or go undergo an audit for 2 years, or, obviously, or we're going to add you to the SDN list if you violate within the next 2 years or something like that. So it'll be interesting to see how that plays out, but that does give them some additional options.
Yeah, and I'll be curious to see if OFAC follows suit, because I do think that makes sense. I mean, if you're going to find a violation, even if you don't impose a penalty, you normally, when there's a violation, there's remediation. I mean, even in the warning letter and no action context, I assume, at least in my practice, generally when we are writing our, final disclosure where we are, begging for a no action letter or a warning letter, we're talking about the sorts of remediation that are potentially on the hook here in the form of an order. So it does seem a little odd that there's no ordered remediation when they find a violation, because you've usually promised to do this sort of stuff anyway as part of your final disclosure.
Yeah, I mean, well, DDTC does that behind the scenes.
Yep.
So they're not going to, if they have a directed disclosure or voluntary self-disclosure, they will often ask a company to undergo an audit, for example, and that's all. But that's all done behind the scenes, and of course, the consent agreements are few and far between.
And it's not ordered. I mean, there is a difference. It's voluntary, and in the same sense that when you do a voluntary disclosure and you're talking about why you ought to get certain credit, and you're talking about the remediation measures, those are all voluntary. Now, if you promise to do them and then you don't do them, you can get in a lot of trouble. But so they're not voluntary in that sense, but they certainly aren't, imposed by the agency.
Although DDTC is pretty aggressive, because they will threaten companies on not allowing them to obtain licenses.
Yeah. I mean, and that is one, that is the one area where, of enforcement practice that is so different from, say, the criminal context, because here your enforcer is also your regulator. And if you're a big company that does a lot of exports, you are going to come to the same agency that's doing the enforcement for licensing, and for, in the ITAR context, for registration, and for all sorts of other potential interactions that you're going to have in terms of, the export side of your practice. And so the ability to kind of, be aggressive in an enforcement context in advocating for your client's best interests is a lot more tempered in this area, because you also have to, the regulator has so many different things that they are able to do after any settlement takes place, that it's just much different than negotiating with DOJ, where DOJ is just like, this is probably, hopefully, going to be the only time that you ever come into contact with DOJ, and after the enforcement action is done, you hope you never see them again, and there is a reasonable possibility that will be your only contact with DOJ. But for our clients, they're going to have many repeat contacts with DDTC and with BIS, even if they never have a violation again, which is also unlikely.
Yeah.
So,
well, it'll be interesting, because Matt Axelrod does come from DOJ, so there is that DOJ hat. He's not gonna forget that. And Taya Kendler, not that she's involved on the enforcement side, but she's also from DOJ. And we've seen, we've seen some assistant secretaries at BIS coming from DOJ. We've seen that at OFAC as well. But everybody has their own, concerns, and I think that, let's talk about the VSDs, because that's big. That's been my biggest concern about this new change in policy.
And I want to hear that, because in some sense I look at that optimistically, but I want to hear what you have to say.
So the policy that was in Assistant Secretary Axelrod's June memo that went out to the enforcement people is he's going to call it a dual track system, where basically they're going to try to fast track kind of the low hanging fruit. So people who are not familiar with this, when you submit a VSD to BIS, it used to go to the field office, Now it's basically sent to a mailbox in Washington. Washington logs it. It then is then distributed eventually to the field offices. But before they're sending these to the field offices, they are triaging them, and they're basically putting them into two folders or piles. You got a stack of paper here. You got a stack here. Here's the bad VSDs, and here are the one-offs, which just doesn't. Here are the ones involving China, Iran, and Russia, and here's the one involving Spain or Germany, and you have 2 violations here, and you have 20 over here, and they're going to be put into various different categories. So the idea is to try to quickly handle and deal with the VSDs in the lower hanging fruit category, possibly with a warning letter, without even having to go to the field offices. The others are going to go to the field offices, and then they're going to be staffed out to an agent, as well as this is the big difference, as well as an attorney from chief counsel. This is big. So as it says in the most serious cases,
NSD is
sign and possibly even an NSD attorney.
Yeah,
which I think is a little. I think that's would be. Only in the most egregious, potentially criminal cases that they're going to want to refer to DOJ anyway. So that I hope and assume that would be relatively rare. But in terms of the VSD, this dual tracking, if you will, I'm okay with that process because, yes, I kind of know it when I see it as well. When I'm advising a client, right. I can tell a client, the first question, as we all know, what's the first question a client asks? Is this going to lead to a penalty?
Right. What am I looking at?
And what? Yeah, in your world, what? How many years am I looking at?
Exactly.
And so in your former world as well. And so I kind of, it's the same thing where I know from experience, I can know it when I see it, and based upon BIS has been pretty predictable over the years. And so here's my biggest concern, though. I am concerned that if VSDs turn into penalty cases, then and we have a discernible increase in the statistics, I am concerned that will have a chilling effect on VSDs and is counterproductive to the agency's goals in the long run.
Right. And that gets back to your point about, the folks kind of importing a DOJ model into an agency practice. On the one hand, we kind of need to be more restrained in dealing with the agencies because our clients are repeat players and the agencies have lots of different things that they can do to our clients outside of the enforcement context. On the other hand, at least as I understand it, the VSD programs, particularly with the agencies, are kind of based on a partnership, based on an assumption that a functioning compliance program is going to still have violations and perhaps even more violations because you're looking more closely and you are paying more attention, and these laws are very complex, and so there's certainly going to be violations. Maybe the better compliance program, there are more. And if you're encouraging people to tell the agencies about them, that's only going to work if the agencies respond in a way that is just as understanding as with the clients. That's not the criminal enforcement model. When a criminal prosecutor gets involved, their job is not to essentially have a partnership with the defendant on the other side. Exactly. And so it is a little bit this, I hear what they're saying in this memo about, ramping up penalties and making sure that the bad actors don't get a competitive advantage in the market because they're not paying the same compliance costs that the good actors are paying, and they're doing deals that the good actors wouldn't do. Fair point. But to your point, it is going to be tough to get people to come in and disclose on themselves if then they're looking at if they're not getting much of a discount or much credit for doing it. If basically the reward for disclosing on yourself is the same penalty that you would have gotten if they had found out about it without your disclosure, most companies are going to take their chances. And that's not to say that they're not law abiding. It's just you're supposed to get credit. And if you aren't getting credit, then it's not in the company's best interest to disclose, because the chances of a regulator finding violations on its own are way, way less than they are if you tell them about it.
No, exactly. And even if you have a VSD where a company gets credit because you get that, should get a starting point of 50%. Even if you get a reduced penalty, most companies want to have no penalty. So that's really the fundamental difference. And this comes to what I refer to as the personalities of each of the regulatory enforcement agencies. OFAC has a different personality on enforcement matters as from BIS, and BIS has a very different personality from DDTC.
Yep.
And these personalities are very important because it leads to its track records, and those of us who deal with these agencies on a regular basis, that gives us as counselors an ability to provide our clients with guidance on how they should act. So DDTC has been very successful in training the big defense contractors to disclose almost everything. And because they want to use the partnership model that you mentioned. And it is a partnership. And only when there's going to be a huge number of violations, or there's going to be a recidivist, which we see many of the more recent cases, or hundreds of violations, as we've seen in some of the cases, or really truly egregious, will DDTC lead to a consent agreement. But they will work with the companies to try to get them back into compliance in a behind-the-scenes method, rather than making it public through a penalty case. So I'm concerned that now this did happen in the 90s, that there was an uptick at BIS of voluntary self-disclosures that did lead to civil penalty cases, and word got around amongst the companies and the bar, and it did lead to fewer disclosures from my experience, because ultimately we as outside counsel, all we can do is to give management and leadership the facts and the pros and cons, and ultimately it's a business decision. And this is the problem. Business people make business decisions based upon risk, and if there's a higher perceived risk of a disclosure, and that and there's very little risk that this issue will be brought or found by the agency, then what are they going to do? Possibly choose not to disclose.
Which, to be fair to the companies and even to be fair to the agencies, I mean, that is part of the model. Like, it is a voluntary disclosure. It's not a mandatory disclosure. And so
exactly.
the agencies say this program is premised on the idea, if you tell us, you will get considerable leniency. If that doesn't work, the company, actually, it's obligated to its shareholders to act in the company's best interest. And so if what they know is the risk of disclosing is vastly higher than the risk of not disclosing, who would ever disclose? I mean, you could arguably be subject, again, not my field of expertise, but subject to a shareholder lawsuit for that as well. Because if you're just disclosing, knowing that the penalties are going to be substantially higher than the risk is going to be substantially higher to the company than for not disclosing, how can that be an interest decisions that's made in the best interest of the company? So I guess regulators beware. The tougher you get particularly on voluntary disclosures, the less likely it is you're going to see those in the future.
So time will tell. So stay tuned.
All right. So we've gone through the first half hour on topic one. So I think we're going to have to go to the lightning round for the rest of these. So let's turn to another development in 2022, another major development in 2022, and that came in at the tail end of the year when DDTC came out with its ITAR compliance program guidelines. And we won't go through those in any great detail, other than to say that the DDTC's compliance guidelines come on the heels of OFAC's. I think they called it a compliance framework, and BIS has some compliance guidelines. Doug, what do you think is kind of new and exciting, if anything, about these new compliance guidelines from DDTC?
Nothing.
Yeah, that's my view too. I mean, it's good that they have them. But there's nothing that I saw there that I was like, oh my goodness, they're doing this different.
I don't want to discount them per se, because they went from 4 pages to 63 pages.
Yes.
So there's more paper and there's more words, or more virtual paper, and there's more words. I do think it's a good idea that DDTC did do this. I would say that the vast majority of compliant companies were already implementing most of this, based upon their experience with other agencies. And also, if you recall, this is now, it's now a little bit, for many people don't even remember this, but to pull this off of your dust shelf, do you remember the Nunn-Wolfowitz report? So the Nunn-Wolfowitz Task Force report on best practices, which was issued in 2000. So now it's hard to believe that makes me
23 years ago.
Almost 23 years ago. That was as a result of an enforcement case brought against Thales. And one of the things that Thales did as part of their mitigation efforts was they commissioned this Nunn-Wolfowitz, Sam Nunn, former senator from Georgia, Paul Wolfowitz, who became the head of the World Bank and was, had been in the defense industry before that. And this, it's worth looking at. It's 85 pages, and so you should. That was the gold standard, and I've used that for years before. As a part of an ITAR compliance program when I'm implementing one for a client. And then I took BIS's compliance program guidelines, or export management control program, which they've had for many years. So if you look at what DDTC did, it's not earth-shattering. It's more meat on the bone, if you will, for the other elements of what they've done in the past. But these basic elements, the 8 elements, Nunn-Wolfowitz had 10 elements. OFAC has their own number of elements. But the bottom line is that they're essentially the same. Number 1, management commitment. And then, record keeping and training and the like. So there's nothing really earth-shattering about this, other than now they can point to this and say, hey, we want our regulated companies to make sure that they're aware of that.
Yeah, it's a good compendium of what a compliance program ought to do, and it's got some meat on the bone, but it is a lot like all the other agencies, because as a practical matter, good compliance programs all have the same structural elements, but really it's the people who are running them that determine whether or not they succeed or fail.
Right. And it does have some unique aspects, obviously, that are DDTC unique, such as registration, such as TAAs and other agreements. Those are things that you don't see at other agencies. So you have to obviously, they've mentioned those in there. And again, anybody who's in an ITAR regulated company should look at this. I'm
Absolutely.
Not discounting it.
And for our friends at DDTC, clearly a lot of work went into this. And so
Correct.
It's a nice job, but it's not something that when you read it, you think, oh my goodness, DDTC is going off on an uncharted route in terms of compliance requirements. So. All right.
But
so
I would just recommend people taking a look at the Nunn-Wolfowitz Task Force report that you can find. It was dated July 25th, 2000. And And I've used that as my model for when I do external audits. Before.
Yeah, no, it's actually very good and very detailed. Until this, it was really the thing. Because the other one was 4 pages from DDTC, you had to look elsewhere to kind of get a compliance framework in the ITAR context.
Exactly.
All right, so let's move on to enforcement. And I think, to me, what was most notable about enforcement, both at BIS and at DDTC in 2022, is the lack of any big or even very many enforcement cases. What do you think about that? And then I guess we can talk quickly about the enforcement cases that did take place.
Well, a couple things. There are a number of cases in the pipeline at all the agencies.
Yes.
So we can't discount that. I do think COVID has still, people still aren't, BIS people aren't going into the office that often. Depends on the agency, but still, there's still work from home. Things are just not normal as they were pre-COVID. So that's part of it. Also, a change in leadership. There has been turnover at BIS in terms of not the Office of Export Enforcement, but certainly in leadership. There's been a change at OFAC over the last couple of years in terms of both sides of the house on compliance and enforcement. And so I think that there are certainly many things in the pipeline. So that's what led to kind of a decrease, I would say, certainly in 2022 on the number of cases. DDTC is always a few cases per year. 2022, it was actually only 4 cases, 3 against individuals in a unique area of defense services, and then 1 against a small company in California. But I do know that there are some in the pipeline. So we're still going to see those types of cases. So, DDT's always been the fewest of the enforcement cases.
Yeah, I think it strikes me as it's not quite a random blip, because I think I agree with you that COVID and the change in administrations made a difference. And I think our next topic, when we start talking a little bit about Russia, also made a difference, because that was really where a lot of the enforcement priorities were. But since the invasion really only started in February 2022, it's really, it's not surprising that there haven't been enforcement cases that have made their way to big cases. It's kind of like sometimes when you look at the OFAC or the BIS enforcement stats, and they'll have one gigantic case one year and then smaller cases other years, and you'll say, well, the average year was, an $8 billion penalty, but that's because there was a $16 billion penalty and then basically no others. So I think it's just a matter of kind of randomness of timing, and then some of these other factors that we've talked about. But
yeah, I don't look at the averages. I look at the number of cases brought more so than the penalty amounts, because that when OFAC's numbers from the mid 2000s was skewed by the big bank cases.
Right. All right. Well, so let's move on to some more country-specific export controls developments in 2022. And with that, I think you have to start with Russia. And so why don't you talk a little bit, Doug, about some of the new export controls restrictions that went into place. If you want to talk about the licensing requirements, I'll talk a little bit about the luxury goods requirements.
So when it comes to Russia, you have to think about a couple of things. Number one is that, yes, there since beginning of March, more or less, after BIS rolled out the first rounds of changes, there have been significant increases in the number of products, certainly since basically anything on the CCL now requires a license to Russia. But you also have to weigh that against the number of companies who've pulled out of Russia. So that really has dramatically decreased the number of licenses that my clients, and that way I think generally BIS is seeing. Certainly we've been dealing a lot with oil and gas companies who are still either winding down or still trying to get items in. And certainly a large number of oil and gas items were added on the various supplements even if they are EAR 99, for example. So so that's one big factor. There aren't a lot of, BIS is spending a lot more time on China licenses than they are on Russia licenses. And, the licensing policies are challenging to overcome them in most cases, unless it's really going to be used by a country, country group A country, or for a subsidiary of a U.S. company who's still operating from there. I mean, the challenges in Russia are numerous, and that you can talk about that all day. In terms of Russia, the biggest thing that I've been seeing is aircraft related issues. Yeah. So that's been the biggest challenge, certainly for aircraft parts and components for safety of flight. But OFAC isn't all that interested in licensing aircraft parts or components for aircraft that were leased and were not returned to the lessors. And that represents a big number. And that's been a big issue. And that's going to, I've been dealing with that. That's going to go on litigation for the next 2 or 3 decades in terms of the fallout from insurance claims and all these aircraft that are now sitting in Russia on the ground. In most cases, some are still flying, maybe not for very much longer, but that's been the big issue. The revocation of license exception AVS was huge, and we've seen that from the enforcement side as well. But that's been so that's been the biggest. Those are the biggest sectors: oil and gas and aviation in terms of Russia.
Yeah, I mean, I will say, from my perspective, most of the clients that I've worked with have pulled out. There have been issues with respect to divestment that have actually come up in the export control side, mostly because if you're pulling out, but you're transferring anything in your office to the new buyer, it is an in-country transfer, and if there's anything subject to the EAR that's on the CCL, you do have potential licensing issues. Although
exactly.
the clients that I have had very few items that are subject to the EAR as part of the transfer, and my advice to them has been to destroy any items so that it is EAR 99 on your way out. And since there have been so few, that is generally the way that clients have resolved that issue, is to essentially disable the items so that they become EAR 99 and don't require a license to transfer in country. But which is, I've had a number of clients that have said, you're telling me what? Your advice is to break this with a sledgehammer? And I'm, yep, that is state of the art export controls advice. And I think, the other big change was this luxury goods requirement. And for companies that, make and potentially sell luxury goods, or did potentially make and sell luxury goods to Russia that were EAR 99, that's really the only big change, is that there is this licensing requirement. And there's a long list, supplement 5 to 746.10 has a lot of EAR 99 items on it. So it's not just items that are on the CCL that now have licensing requirements if you're in the luxury goods area. And the other thing that's interesting about that, and has been difficult for compliance terms, is that it doesn't just apply to exports to Russia. It applies to export to Russians, even when they're out of Russia. And so that has kind of been a compliance nightmare. But still not something that has come up a ton, because I think that you have, I don't think that anybody who's making goods that are on the luxury good list is actually trying to do anything in Russia. And so it's really just the compliance concerns for the out of Russia sales that are, still giving people fits.
So we were just focusing on BIS, but I think from the OFAC side of the house, by contrast, there's a large number of license applications.
Yes.
And that relates primarily to blocked funds.
Yep.
So I've been dealing all the time with license applications for blocked funds, for payments that were blocked by the U.S. correspondent banks after the large Russian banks over 2022, starting in February and then expanding. Then there's been the large U.S. commercial banks, because of de-risking and other reasons, are very, very cautious, and they're gonna if there's any doubt, particularly on the 50% rule, what are they going to do? They're going to block, report, ask questions later, and then it's up to the beneficiary or the remitter of the funds to have to figure out how they're going to get their money back. And this has been a problem. So there's tons of OFAC licenses that are in the pipeline, and this takes a long time. OFAC is very, very slow.
Yeah.
And that's a big issue on the OFAC side.
Oh yeah. I mean, so it is kind of the perfect storm from the OFAC perspective, because on the one hand, my experience was that every financial institution in the world after February 2022 was giving incredible scrutiny to every transaction that even potentially touched Russia, and was erring on the side of blocking. And so you have kind of this really aggressive compliance function in the financial institutions, over compliance beyond anything that I've seen before. And then on the other hand, when the clients have the blocked funds and they come to you and say, well, how do I get this unblocked? And you see a case that looks like the funds really shouldn't have been blocked, you still have to tell the client, okay, we're going to put this together. We're going to go to OFAC. How long is it going to take? A long time. What's a long time? Are we talking a few days? Are we talking a few months? And it's like, no, it could be a few years. Like it's really an unpleasant conversation to have, that I've been having a lot, because, the time frames for OFAC are really measured in years generally, and not months. I've had, and I'm sure you've had at least as many, if not more, but I've had some cases where they've gone pretty quickly and gotten to the right result. But I have to say, usually it takes a lot longer.
They're measured in dog years.
It's true. It's true.
So I always say months. It's months.
Yes, I say months. I do say months, and that can be fair, but I think years.
It could be. It could be. Yeah, I mean, I got a license. Things can pen and OFAC can stick. Now, I have to say that Brad Smith, who's deputy director of OFAC, he has been very focused on metrics, and he has to give him credit. He's done a very good job of trying to get licensing, trying to get pending cases done faster. But just the volume of cases with Russia and other countries, it's very challenging.
Right. I mean, for our friends at OFAC, that is not a criticism. We know you are overwhelmed with license applications, and that they are very complicated and can take a long time. But it does, from the outside, when you have to deal with clients who, expect to hear that a licensing decision will take days or weeks, to try and set expectations can be very challenging. And
I've tried to get OFAC in many cases where we're dealing with a large number of block transactions for some commercial banks. I'm trying to get OFAC to think out of the box, which is not always easy. And I've tried to get them to try to do bulk licenses rather than like payment by payment. Why don't you do 10 at a time, or do 20 at a time, or do, for this one particular bank, you can do attach a spreadsheet like BIS does for items. So the transaction by transaction approach, like in the normal world, is okay, but in the current world is highly problematic. And they can be much more efficient if they kind of revisited their licensing strategy in many cases.
Agreed. And also the duration of some of the licenses, because, if they made them last longer, then you'd have to renew less frequently. But question for another day. So let's move on. I do want to talk about two more things quickly, because we're running up on an hour, and I think we want to try and end it there. So the first thing quickly, you've already talked about it quite a bit, Doug, in terms of the crisis that's brewing with respect to replacement parts for airplanes in Russia. And I think you're exactly right that it strikes me that BIS and OFAC are not inclined to grant those sorts of licenses. But I say crisis because those planes are still flying, and so at some point something bad could pretty easily happen as that goes along. The other part about the aircraft that has come up, and you may have seen it before. I'd never really seen an aggressive use of General Prohibition 10 like has occurred in the context of Russian aircraft. You mentioned that AVS was withdrawn for flights to Russia, which means that every flight to Russia that doesn't have a license and has a U.S. origin aircraft, which are most aircraft because many of the engines are U.S. origin, and the engines are usually more than 25% of the value of the planes. So you have all of these flights going into Russia, and none of them are authorized, and so they're an export to Russia without a license. BIS has taken the position that once that happens, that anybody that everyone is now on notice that the plane is the product of an export controls violation, and so nothing can happen with respect to any of those planes, and they become, according to the BIS, and now according to the U.S. attorney, I think there's a pending forfeiture action in SDNY. Sure. They become subject to forfeiture. They become subject to seizure. Anyone who provides parts to the plane or even provides services to the plane is potentially at risk for a General Prohibition 10 violation. I did want to mention that because I've not seen such an aggressive use of General Prohibition 10, and I'm wondering if this is where it's going to be limited to, or whether we're going to see it more broadly.
Well, it was really the perfect way to use General Prohibition 10, although I would say that OFAC's guidance is extremely broad, and we're trying to get clarity on certain aspects. And that type of guidance is not always easy to get. So, for example, one of the issues I was dealing with is in terms of because it does, if you look at the OFAC guidance, it talks about prohibition on financing. Well, does that mean if you have a lease payment, can a lessor still get a payment for the leased aircraft? And that's been an interesting challenge.
Yeah.
Because it's not an OFAC issue necessarily, if all the parties are no SDNs involved. So there are lots of interesting challenges there. I do certainly think that for aircraft owned by Russians that may not be even just general aviation aircraft, Gulfstreams and Bombardiers and other things that are owned by Russian nationals. These aircraft companies, because they have FBO, fixed base operations and maintenance operations in Europe, they're very careful, and they will basically, if they sense any Russian connection, they're probably not going to do it without an opinion from counsel or authorization from the agency. I do agree that it will be interesting to see if there's some sort of crash, unfortunately, in Russia, and they're going to blame the U.S. government, for not licensing things. And we've seen that in Iran.
Yep.
So, but in the Iran context, those were historical aircrafts that were, owned by Iran Air, for example. These are aircraft that are owned by Europeans or Americans, through Irish and other leasing companies. And so this is a big, big problem, and it'll be interesting to see, but there's no shortage of issues in that area.
Yep. Yeah. And I do think that, this becomes complicated on the U.S. side because, the worry for all of the aircraft is that they're going to be used for the military. So it is the point of the sanctions is to deter Russia from engaging in a military conflict, and aircraft have obvious military uses, and so you really do see the U.S. side on that and where they're coming from. On the other hand, if planes start falling out of the sky, and it's because the planes haven't been able to get replacement parts, it is not going to be good from a public relations standpoint, I think. We'll see what happens. So we've only got a couple of minutes left, and we do want to kind of close with what we did an entire podcast on a few months ago, and that is the new rules that came out in October of 2022 with respect to supercomputers and superchips, and really we're all focused on the PRC and trying to deter both manufacturing of those items in the PRC and keeping that technology from being exported to or used in the PRC. What are you seeing now, Doug, with respect to a few months out? Like, are you seeing the same issues you saw in October, or have they evolved?
So we're now 3 months into it. Hard to believe because that
Yep.
was issued on October 7th. Wasn't published until October 13th, but most of it was effective October 7th. So it's hard to believe it's been 3 months. I can tell you literally every day since then, I have dealt with a China, I call it the advanced supercomputing rule or
Yep.
advanced computing rule, dealing with an issue for a wide variety of clients on that issue. I will put this into several, I think over time, you could look at it. The first month was disbelief. The second month was understanding and trying to understand. And the third month was acceptance. So now we're in the acceptance and we're in the acceptance phase of things. And now we're in the all right, we have to comply. How are we going to comply? So my big takeaway from the rules are, number one, it's still my original view. It's not as big as some people thought it was. It does affect some companies more than others, but it's still advanced in supercomputing and hardware driven in the integrated circuit semiconductor manufacturing space. So I'm not discounting that. That's one takeaway. The second takeaway is it is important to do due diligence. And how do you do due diligence is through in-use statements. So we've seen a proliferation of in-use and in-user statements that companies are being asked to sign or are asking their customers to sign, that their customers, these items are not going to be used in the production development of advanced and supercomputers in China. The only way a company can protect themselves is by getting one of these statements. So we are seeing that, but they should be narrowly crafted. You should push back if you get one that's highly. I've seen some really bad ones, even for some big companies that I think that were, I think didn't reflect a good understanding of the overall scheme of the rule. So you can certainly, if you're asked to sign one, ask questions and push back to the extent you can. And if you are preparing one, talk to counsel who understands the rule. And then the third aspect is the U.S. person issue.
Yeah.
So OFAC did issue some FAQs, the first round of FAQs for the advanced supercomputing rule at the end of November, right before the U.S. Thanksgiving holiday. They tried to be helpful. There were some very positive aspects of that, like what's the definition of a semiconductor manufacturing facility? That was very useful. But on the U.S. person part of it, I think that they weren't successful. This has been, in my opinion, the most. It's not the most significant because it only affects
U.S. persons
US
in China.
persons in China or outside of the U.S.
Right.
But it is confusing, and it was initially viewed as being akin to an OFAC facilitation prohibition by U.S. persons, and I think OFAC tried in that FAQ to try to limit it to what they were really focusing on, which was the shipping and the supplying and the approval of shipments, and not covering lawyers who are U.S. persons,
right?
In Europe or in China, or they're focusing on servicing, was another one of the prohibition. So I think that there's still a lot to be clarified. And I've done a lot I've talked to OFAC about it, and I've done a lot of guidance to clients on the limitation. But, I was dealing with some executives who are U.S. persons for Chinese companies. And like, do I have to resign? And I'm like, well, what is your role in the company? Generally speaking, the higher the role in the company, the less that they are going to be doing one of these activities that are the prohibited activities.
Right.
And it's not as broad as OFAC facilitation. So that's a key point, and I think now we're into the acceptance and phase of things, and I think people are, it's all being kind of, the dust is now settling on and people are accepting it.
Yeah, that's been my experience too. The one thing that I would add to that is that especially for non-US companies that have either plants in China or have been doing work in China or have been working from Europe, supplying to China, they one, have a lot more items subject to the EAR than they realized, and two, they have no idea what the classification is for the most part. And because of some of the rules actually apply to items subject to the EAR, and then if they're used in the production of certain items to make products that fall within certain categories, usually for the supercomputers or super chip categories, those ECCNs, it becomes very complex to work with those clients because they're really having to learn a whole new language, because even though they had items that were subject to the EAR in their supply chain, they weren't paying nearly enough attention to them because, they basically saw that there was no license required to ship to China, and that was about it. And now they're much more focused on these sorts of issues and exactly what's going on the ground in China.
So that's exactly right. I mean, the point about the foreign direct product rule cannot be stated how important it is. So number one, people have to realize and there are now 8 different foreign direct product rules. So when the foreign direct product rule applied to Huawei only, that was manageable because companies may not be selling to Huawei, or they can get a license for non-5G. The second part now is because of the new rule, now you have it added footnote 4, those new companies that are subject to the foreign direct product rule, and then now the advanced and supercomputing foreign direct product rules. So the foreign direct product rules are another aspect of the overall, depending on your client base, and what, if you're a non-US company, and you're in the integrated circuit space. I wrote an 8-page memo to a company recently in Europe about analyzing the impact of the foreign direct product rule on their business. Now, I think ultimately it's not going to be immediately, but if companies can't use US equipment and US software, they're going to find other sources.
Right. No, I agree, and I think that may be where we leave it is, and it'll be a topic for the next episode of Embargoed, or the next time you come back when we can talk more about this rule and some others. Is if the U.S. There is going to be a scenario where the U.S. rules are so much more strict, but the technology is not restricted to the U.S. that European companies and other companies are going to fill the breach.
Absolutely, and also indigenous development in China,
right?
Of their own technologies,
right? Well, that and this might speed it up, ironically, because now the Chinese may be forced to do things where they'd been relying on the U.S. previously. But we'll see how that plays out. All right, that's the final word.
Well, we covered a lot of topics in a short period of time.
We did.
So always fun, and there's certainly no shortage of issues, and we can. It's nice kind of doing this periodically, and then we can kind of see where we were and then see where we're going. But certainly my takeaway is that this is the golden era of sanctions and export control lawyers and consultants. There's certainly no shortage of issues for us to deal with, and they're not going away anytime soon.
Excellent. Well, that's the final word, and thank you, Doug, for coming on the podcast, and see you until next time.
Until next time.
Stay sanctions free.
Produced by Heartcast Media.